Okay, so last time we primarily focused on the initial hearings, our detention hearings, our dispo hearings, both bringing up the idea of reasonable services at those hearings more, and then also what we can do early on in the case to ensure that when we come back at the 2-1E, we have a good record so that if things aren't getting done to help our client, we are more likely to have that reasonable services argument. So we talked about, as I'm sure you all vividly remember, making sure we have detailed case plans, objecting to things in the case plan that can't be done by our incarcerated clients, things like that. We wanted to start today with the actual bulk of what we think about when we think about with reasonable services, which is our 2-1Es, our 2-1Fs, and our 2-2s, where I think we're doing the most of litigating the issue of reasonable services, and that's where a lot of the case law on this sort of lies. We put up in the first couple slides the 2-1E, 2-1F standards, just to sort of focus us a little bit more clearly on what we're doing at the 2-1E. And remember, at the 2-1E, the court has to make a finding by clear and convincing evidence that reasonable services have been provided to our clients. And the department has the burden, again, to show by clear and convincing evidence that the department has provided reasonable services to our client. I know a lot of times we like to think that it's sort of our duty to raise these issues, and it is to raise these issues, but it's the department that has to show that they did what they needed to do. Let's see, 2-1F, again, and the 2-1F standards, either the child's going home or there's enough to show that your client could possibly get the child back by the 18-month date. And then, let's see, we go to 366.21G1, which talks about continuing to the 18-month date only if there's a substantial probability and reasonable services have not been provided. And we will get into the situation with the 2-2 and what happens when we're at the 18-month date and what do you do, because I think that's, to me, that's the stickiest issue when it comes to reasonable services. And so we have the case law on that, and we'll talk about what you're going to argue there. This is okay. The next slide we've determined is repetitive, so we're just moving on.
And just the important thing to note for each of the review hearings, specifically the 2-1E, because that is your first chance to raise a reasonable efforts issue, is that if you have a case for no reasonable efforts at the 2-1E, I urge you not to just submit on the department saying, hey, we'll just give you more FR, like, no big deal, we'll give you more FR, and just pretend that never happened, because, again, as we're going to show you later on in some of the case law, it's going to limit your ability to, if that parent needs extra time to reunify, to extend the periods to the 18-month, to possibly the 24-month, because at that point, if there's been a finding of reasonable services at the 2-1E, and then perhaps the 2-1F, and then you get to the 2-2, and all of a sudden you're like, well, actually, they haven't really been helping all the way along, you've forfeited that argument. So just be careful submitting early on those sorts of.
And the situation is one that we come across all the time, where you get a report at the 2-1E and they're recommending terminating your client's services. You set the contest with the assumption that you're going to make the reasonable services argument, and then all of a sudden you come back with a change of rec. And we should be taught, again, it's up to your client as to how to proceed, whether it's to submit or go to trial and what that means. But that is the, in some ways, most common remedy the department will sometimes try to come up with, which is, well, we'll just submit on 6 more months, and that's something to be a little bit cautious of, because you are, again, submitting on the reasonable services finding. This is what do you do when you identify a potential no reasonable services case, and that's sort of when you're at the 2-1E, you read the report, and you can kind of sense that the department didn't do very much, or you talk to your client, and your client says, yeah, the things in the report didn't really happen the way they said they did. And so obviously we would and courtroom procedure is different, but in most courts you would set it for a contested 2-1E. Obviously, we ask for Title 20s. One of the things, I was talking to a lot of people when we were preparing for this, and one of the supervisors mentioned that they'd like to recommend having you just go through the Title 20s and highlight every time your client is mentioned. That's a pretty good test to see whether reasonable services were provided. If there's not a lot of highlighting, that's a good sign for your reasonable efforts contest. You're going to request that the social worker be present or on call. It depends on the courtroom. Some courtrooms don't allow on call, so whatever your procedure is. Cross-examining the social worker. I know a lot of times social workers come off as it's sort of a gamble, but when it comes to actually putting the social worker on the stand and finding out what they did, that's where you're often going to get your no reasonable efforts findings, based on what they actually did to help your client, what referrals were provided, and we should be asking when we're setting the contest to see what referrals were provided, because if there are programs that don't really exist, which is happening, we need to know that, because if they give this, oftentimes they'll give you a packet of whatever, and then if you show it to your client and they say, well, I called all of these, only 2 of them actually exist, and one of them has an 8-month wait list, then again, that's something that the department, that's not reasonable services. It should be what efforts were made to contact the parent regularly, what efforts to set up reasonable visits. Those are the things that we should be asking the workers when they're on the stand. If they're not liberalizing visitation, why are they not liberalizing visitation? Have they observed a visit? Sometimes, especially when, I know we're so excited when we have relatives monitor for our clients because typically they get more visits, but if the social worker isn't observing the visits and doesn't know how they're going, sometimes they're not liberalizing. So if a relative's monitoring the visit, did they check with the relative to see how the visits are going? And if they're going well, why aren't they liberalizing? We know about the calendars. We sometimes forget about the calendars at detention because there's so much to be done at detention. But the calendar, giving our clients the calendars and making sure that they know that they should be writing down every contact they have with the social worker is a really good protection for our clients and a really good way to get a no reasonable efforts finding. Honestly, I just have a case where the fact that my client kept a very detailed visitation log is probably going to protect her from being accused of breaking the child's leg at the visit. So, right. So having a visitation log is really important, and making sure our clients are documenting things can protect us. And making sure, one of the things that you get from reading a lot of the reasonable efforts case law is having some information about what our clients are trying to do also to reunify with their children can be helpful. Some of the case law that is not so great for us, if the parent says, well, I'm not doing anything, I'm refusing, that's not going to be great for your reasonable efforts. The department still has to try to help them, but more evidence about your client attempting to comply is always better for these types of cases. Oh.
You don't want me to take them?
Yeah, sure. Oh, well, the next slide, this is about the 2-5. The 2-5 is really limited, and it's statutorily limited. When we talk about going past the 18-month date, we're not talking about setting a 2-5, we're talking about continuing the 2-2. The 2-5 is really clearly outlined in, ironically, 2-2, and that sometimes confuses people, but it's really clear the specific circumstances where going to that 24-month date is appropriate. And the thing about the 24-month date is that beyond simply just being released from the residential treatment program or the incarceration or INS or institutionalized, beyond that, there's also a best interest prong on that. And that's one that we have to remember and we have to be prepared for, because that can be harder for us to meet sometimes.
Sure. then the circumstances that we're really talking about that are going to apply to the more majority of our clients is when you're looking at to continue the 2-2 to the 24-month date, but you don't have those. Go ahead.
Sorry. Before we get to the 2-2, when you get a no reasonable services finding at a 2-1E, our request should be to reset that 2-1E. If they can't make the Title IV-E findings, they should be resetting that 2-1E. It doesn't toll the 18-month date, but that's what we should be asking for. It should be, we're going to reset the 2-1E for 6 more months. And, yeah, that's...
Yeah.
Is there a case that says that?
I don't have one. If somebody has one, that would be wonderful.
I think whether you call it a 2-1E or not is not as much of the point that you want to make. It's that you want to make sure that a parent is entitled to at least minimum, no matter what the age of the child is, 6 months of reasonable services. So if that first 6 months have not been reasonable, then they should get another 6 months. If that hearing is called a 2-1F, but and the department still hasn't provided reasonable services, and this is a child over the age of 3, that parent is entitled to a year of reasonable services. I mean, either way, you just want to make sure that the timelines that you're looking at, whatever the court calls these hearings, is sometimes immaterial. I've had a court continue a 2-2 hearing and call it a 2-5, or call it a continued 2-2, or call it, I don't know, sometimes they grant a 388 for further reunification services and call it an RPP or a 2-2. I mean, sometimes the courts are calling these hearings very different things. I think the important part is that a child under the age of 3, any parent is entitled to 6 months of reasonable services. A child over the age of 3 entitled to a year long of reasonable services. That needs to take place within the very first part of reunification.
And the case law is clear that without a finding at a 6-month date of reasonable services, the court cannot set a 2-6. And so at that 2-1E, if the court makes a no reasonable services finding, the court cannot set that 2-6.
So, continued reunification services. When you're at a 2-2, and at this point, sometimes this has happened after you've had actual 2-1Fs, 2-1E, 2-2 hearings. Sometimes the disposition has taken so long that you're 18 months down the road and it's a 2-2. So it may be your first reasonable efforts finding. It may be a subsequent reasonable efforts finding. The only way to continue the case for 6 months to the 24-month period is, as we discussed, under 2-5, or if there's not been reasonable services provided. Now, I know that we've always said, a lot of people have probably heard that you can't argue reasonable services at a 2-2 date. That's not entirely true. You can argue reasonable services at a 2-2 date. It's just that if you've submitted all the way along on reasonable services and this last bit of reunification is the only thing you're hinging on, and your parent hasn't done something on their part to at least be trying to comply with their services, you're very unlikely to get the court to say, well, between the 1 to 12-month date, services were reasonable, but between the 12 to 18-month date, they weren't, so I'm extending this an additional 6 months. However, that does happen, and that's the cases that we have for you on the next slide.
Right, and it seems very fact-specific, and so these are cases, if you're going to make the argument, that you probably want to have an understanding of. And it's talking about when you're going beyond that 18-month date, which is what oftentimes we really want. We all sort of know our Elizabeth R. arguments. Elizabeth R. is the special circumstances, mother was developmentally delayed, and in Elizabeth R. there were no reasonable efforts finding at the 2-1E and the 2-1F. And so the mom in that case goes beyond the 18-month date, but again, that's a pretty spectacular circumstance that we're not often faced with at the 18-month date.
And she was in a mental, or she was like 5150 for I think 15 of the 18 months of the reunification period, or she was in a mental, yes.
I just want to add what's really interesting, because I was covering for one of our attorneys in 413 before Commissioner Trong on Monday. And one of the ladle attorneys was going to make an argument to go past the 18-month date. And I heard Commissioner Trong say, which is the premise of Elizabeth R., the commissioner wasn't going to whether it was special circumstance or not. A lot of times we're going to lose because it's not special circumstance. But I heard a commissioner who's been on the bench for 1,000 years go, my hands are tied. I have no ability to go beyond the 18-month date. Now, if we can't show the special circumstance, we're going to lose. But if we can weave an argument, either for the bench or for the writ, that shows it, do not take from the bench this business of, gosh, it really looks like mom at the last minute did everything, probably could reunify within the next 6 months, but my hands are tied. 18 months is a magic number and I can't go beyond. So Elizabeth R. still very much is alive and well when you hear that from a bench officer.
If you're not so lucky to get the amazing facts of Elizabeth R., I would take a look at Tracy J. and Taylor J., and we have the sites there, and they're both other cases where the appellate court reversed a TFR at the 18 months and demanded more reunification services.
And there had been prior reasonable service findings in both those cases.
Right, and Tracy J. we talked a little bit about last time. And again, the Parents' Council on that case did an excellent job of putting forth significant efforts to show what their clients had done during the period of reunification. The clients were, or the parents were developmentally delayed, and the social worker basically in the report said, I don't think they can understand any of this. I don't think they can ever parent these children. I can't remember if there were 1 or 2 children. And the Parents' Council did an excellent job of bringing numerous service providers in who said this is the progress that they've made. And the court was faced with, at the 18-month, the fact that the parents' visits were still monitored and terminated services. And the appellate court said it wasn't reasonable services to go 18 months without liberalizing the parents' visits, and ordered more services even past that 18-month date. And there was a child under 3. So that's something to keep in mind. Taylor J. is the other case that I would also look at, because this sort of circumstance, I think we're faced with a little bit more, which was mom was doing some things, the child was older, and they were having some unmonitored visits. And so I think the child was 14 or 15. And there had been reasonable service findings previously at, I think it was a 2-1E. I'm not sure if there were separate findings at a 2-1E or 2-1F, or it was just continued to that 2-1F date. I can't remember. But the department had only provided her with referrals, and she was out of county, and they weren't providing with the referrals in the right county. But also in this case, there was a sense they were having unmonitored visits already. This was moving in the direction of FR. And so the appellate court reversed the TFR finding and ordered the court to order more reunification services for a time period it deemed reasonable. And so that's a good case to rely on. If you're in one of these situations where the child's a little bit older, this isn't going straight towards adoption, and your client just needs a little bit more time for whatever reason, and the department really hasn't kept up what they should be doing past that 12-month date. The bad case, though, is Earl L. And it's just a little, it was a little bit smaller on our list. To it on the second page. Oh, apparently we go to it on the second page. No.
The common thread, just before we move on to Earl R., between Tracy J. and Taylor J., is that, again, Tracy J., the child, was under 3, so it's not just older children, but the common thread is that the parents in these cases were really doing something, quite a bit of something going on their end. And that's why on the page where we told you what to do when you identify a no reasonable services case, that you want to obtain any information about your client concerning their independent efforts to comply with the case plan. Because what the court seems to like to see when they're going to be willing to extend reunification services beyond the 18-month date is that this parent is really trying and the department maybe is not actually doing what they should be for this parent who's stepped up to the plate and really wants to reunify with their child. This is not going to be like an escape hatch for some client who's really like totally slept on, their job and around the 17th or 16th month decides, oh, I'm going to roll in a program now, and hasn't been keeping in contact with the social worker. This is a circumstance where the parents are really trying on their end. They're doing some things. It's just that the department has really dropped the ball in assisting them.
And so, on the flip side, we have the Earl L, which Parents Council submitted on reasonable services findings at the 2-1E and the 2-1F, and then we get to the 2-2, and the issue of reasonable services is raised for an incarcerated parent. The court finds no reasonable services, but TFRs and sets the 2-6. And in that case, the appellate court said, yeah, that was the right thing to do, because there was no likelihood of return. This wasn't a parent who was doing everything they could possibly do. This was an incarcerated parent. And yes, the services between the 12 and the 18-month date were not reasonable, but the court still could set the 2-6. And that's something, if you're making this argument, you should also be aware of.
Question. Is there any indication that there were services at the father's place of incarceration?
I don't recall.
I think that there had some of the indication, if I remember right, you read this case more than I did, but if I remember right, essentially from the appellate court opinion, what I kind of gathered is that they said that maybe there weren't reasonable services the entire time along, but the parties had all submitted at the 2-1E and the 2-1F on services being reasonable, and dad was incarcerated for a period that was going to extend well beyond a 24-month period, even if we were to extend it out to the 24-month period. I don't remember the exact circumstances of the services that may or may not have been available at this dad's place of incarceration, but the point, the major point that I took away from what the appellate court was saying is, what they submitted, 6 months, 12 months, this wasn't just one hearing where the attorneys were like, oh, it looks like it's reasonable. It wasn't as if the 6-month hearing there was no reasonable services, then the department stepped it up for a 6-month period, and at the 2-1F maybe there were reasonable services, but then they dropped the ball again. This was one where the Parents Council said, it seems like it's going fine, and then time comes where it's TFR, set of 2-6, we're gonna have this child adopted, and the parents' attorneys then jumped on top of it and said, wait, but they haven't been checking what services are available for my client, they haven't been contacting this person regularly. I think there were not any contacts between the 12-month and the 18-month hearing, if I recall correctly.
But the opinion does rest on the fact that the appellate court said, well, we think there's just the smallest chance that father's going to benefit from having more time. And that was their reasoning.
There were, now I'm recalling, I think there were minimal services available for him. There was like something like a 12-step, there was something that he didn't take advantage of as well at his place of incarceration. The entirety of his case plan was not available, but there was something there that he did not take advantage of, which also rested on it. And that's why on the next page, on where we talk about section 366.21G, where the general rule is that the court may not order a 2-6 hearing set unless there's reasonable services, clear and convincing evidence that reasonable services have been provided or offered. It's, again, a totality of the circumstances analysis. It's not that you can't set a 2-6 if there's ever been a finding of no reasonable services. It's that a 2-6 hearing should not be set where, in looking at the entirety of the circumstances, it doesn't seem like this family has been offered reasonable efforts at reunification. The case that's positive for that is Mark N., which basically says that in that case there had never been a reasonable services finding. You didn't have a 2-1E, a 2-1F, a 2-2, any reasonable services finding at any hearing. You can't set a 2-6. But then we have the Earl L situation, where is exactly what we were talking about when I said, if you identify at a 2-1E a clear no reasonable efforts case, do not just submit on the department's concession to give you more FR. I mean, if it's a wobbler, I get it. Sometimes you don't want to take the chance and go to trial. and lose a no reasonable services argument and also lose continued FR for your client. But if looking at the facts, you have an incarcerated client who the department's made no contacts with whatsoever. You have an out-of-state client and an out-of-country client who the department's made no contacts with whatsoever. I wouldn't just take the department's concession on those.
Okay, and now we get to our special cases, which is where you're going to find a lot of your no reasonable efforts issues, because the case law is just clearer on a lot of these clients, the incarcerated clients, the deported clients, the developmentally delayed clients. So I think a lot of us are pretty aware that when we have an incarcerated client, this is an issue we should be raising. One of the nice things about 361.5E is that it really does outline a lot of the things that the department should be doing for our incarcerated clients, and that's sort of listed below. And even just going through 361.5E when you're cross-examining the worker is a good sort of roadmap as to what did the department provide reasonable efforts. Did they do any of these things that they can do for your client? Precedent J is a reasonable services client case with an incarcerated client. And this was about visitation for an incarcerated client. Although do be careful, the cases do take into account the distance. So if you have a client in state custody and the distance is far, that is something that the appellate court looks at as to whether visits will be reasonable when it comes to a reasonable services finding and how often those visits should occur. But if you have a client in local custody who's serving their time in county jail, that is something, that is a reasonable services issue if your client has no visits.
And even if they're excessively distant, I feel like all too often, one of the biggest problems for our incarcerated clients is no visitation ends up getting set up or facilitated. Even if there is an excessive distance, when you have a verbal child, we should be pushing for phone calls, calling cards to maybe be set up for these parents. I think that those are part of the reasonable services that could or should be provided.
And a lot of places of incarceration have programs for older children where there are transportation buses and things like that. And we should be looking into that for our clients who have FR but are placed far away from their child. That's something that we can be advocating for.
Yeah, so go ahead.
What about like the younger children, even with the visitation? Because I know in my court, if the kid's younger, he will not order visits.
I believe there's a case, I don't have it off the top of my head, that says age alone cannot be the reason to not order visits for incarcerated client. So the order has to be made, and once the order is made, as we talked about last time, the order has to be followed, and the case law is pretty clear on that. I can get it for you, I just don't have it.
Right, so it looks again sort of a best interest sort of analysis. You're looking at the age of the child in combination with the distance, like is this going to be a long car ride for a very, very small infant, and any special issues that child may have, like if that child has medical issues, obviously that's going to make it a little more difficult to go on a long car ride versus, yes?
I've also heard in my courtroom when sometimes they make the same order if it's a baby or a toddler, they say the same thing, like visits. They're not going to order visits for an incarcerated client. And sometimes they say the reason is because a lot of places don't allow babies or toddlers to visit, and it's more rules about where they're incarcerated as opposed to, so what do we do in that?
If the court's going to make a no visit order, there has to be a detriment finding, and the age of the child alone cannot be detriment. So I think we have to be objecting to those orders. If the parent's place of incarceration doesn't allow it, you're not going to get the visit to happen. But I don't believe we should be submitting on no visit orders when there's no finding of detriment. And that's the thing, when they're not ordering visits for our incarcerated client, that's basically no visit order. So if they don't have detriment, we have to be getting those visits at least set up.
You should also be looking yourselves for how that's going to happen. Talking to your client's relatives and trying to find someone who will volunteer to do the drive. Because if you've got a grandparent who's willing to drive the 3 hours there and the 3 hours back, That's one thing, as opposed to expecting the judge to make a social worker do that.
Absolutely.
I'd also add that we have a Los Angeles Superior Court Incarcerated Parents Committee in which Judge Downing chairs. In fact, it's meeting right now. They usually meet once a month. In our law firm, we have an attorney that attends that meeting. So if you have, I don't know who in your law firm attends that meeting, but Judge Downing has been very aggressive in the last number of years educating the bench as to this precise issue. In fact, 2 years ago, she set up a field trip so that all the bench officers could go to California Institute for Women in Corona so they could actually